Pose, let's be real. Sometimes the defendant's interrogatories are intimidating, or at least they feel that way. And that's why it's important that you know your facts and you know the law. Know what you need to prove. And this is why I encourage you to conduct an IRAC, the issue, rule of law, analysis, conclusion. I did a video on that, and I'll leave that link for you to review that if you need to. The second part of this is, as Kenny Rogers would say, you got to know when to hold them and you got to know when to fold them. And what are we talking about? You got to know when to object to the defendant's interrogatories and how to object. And what we're going to do today is look at objections that you can use and how to use them. So let's get started. So we are essentially talking about avoiding boilerplate objections because they can get you sanctioned. So what is a boilerplate objection? It is called a boilerplate objection because the response to the defendant's interrogatory merely states the legal ground for the objection without specifying how the discovery request is deficient and without specifying how the objecting party would be harmed. And pro se, if you don't respond, you could waive any objections to the discovery request. And what this means is that any answers that you serve must contain no objections to the question. Further, the opposing side could ask the court to apply sanctions against you for not responding. So let's look at some interrogatories that may require objections and examples of written objections. Objection on the ground the interrogatory is annoying, embarrassing, and it is oppressive. The rules would permit the respondent to object when being required to answer the interrogatory would result in the respondent's annoyance, embarrassment, or oppression. And it would look something like this. The interrogatory states, please provide a detailed list of every, see those underlined words, pay attention to them, single person you have ever interacted with in any capacity, including their full name, contact information, and a description of every conversation you have ever had with them, regardless of relevance to the current case, as well as any personal opinions or beliefs expressed during those interactions. I mean, come on. Who knows every person they've talked to and what the conversation was about? Now, that's clearly annoying, right? And it's also oppressive. Now, concerning personal opinions or belief, if the question is not relevant to a fact or the application of law to the fact, the question may fall in this category. So you object and explain why you're objecting. Also, be aware that when the interrogatory asks for beliefs or opinions, it may be that the defendant is trying to get your legal theory. Remember, Your legal theory or theories, they are yours. You do not have to reveal those theories. Okay? Confidentiality. That would include things like confidential company information, privacy rights, trade secrets. Overly broad, unreasonably cumulative, or undue burden and expense. And I'm going to show you 7 examples. Watch this. Defendant requests documents showing an event did not happen or does not exist. The respondent may object on the ground the question, or if there's a phrase, calls for documents proving a negative. As the old folk used to say, you can't get blood out of a turnip. That's humanly impossible, isn't it? Questions requiring pro se to speculate as to what documents might be responsive. You don't speculate. Questions that do not pinpoint the time and scope. Requesting documents and information that is in the physical possession of the defendant. And documents or information not in the physical possession of the defendant, but the defendant has access to the documents and information. And questions asking the pro se or the respondent to prepare documents that do not exist. Here's how you want to think about this. If the question asks for something that you cannot provide and it is oppressive to you, it probably falls in this category. State your objection and explain why you object. Privileges. Communications between an attorney and a client that were made for the purpose of obtaining legal advice may not be disclosed unless the client consents to the disclosure. There are other privileges that litigants need to know about. The battered women and sexual assault counselors. Healthcare professional privilege, such as psychiatrists, psychologists, physician, family and marital therapists, social worker, professional counsel. Husband and wife privilege. Be sure to read the jurisdictional statute or local rule for each privilege. Protected work product. This information requested is protected from disclosure by the attorney work product doctrine. Documents that the pro se or the respondent prepare in anticipation of litigation. And something I want you to be prepared for. Often the defendant will ask for your notes, even notes that you wrote on your calendar. They will literally ask you for your calendar. If these were prepared in anticipation of litigation, generally they are your work product and they are protected. Vagueness and ambiguity. Vagueness And ambiguity is usually associated with requests that include terms that have multiple definitions and meanings. For example, please describe the actions of the defendant. Well, what does that mean? The actions. Another one is, please identify the important witnesses you intend to call to trial. Well, what does that mean? The important. Here are some other objections that can be used. Number one, the question assumes contested facts. In other words, the question, the way it is framed, is presuming the truth of a fact that is disputed. Two, the question is argumentative. The question is conclusory. The question calls for a conclusory response. The question contains subparts, is compound, conjunctive, or disjunctive. And five, the request is duplicative of request number, whatever request was previously asked, you state that number. Now, the objections that I reviewed is not an exhaustive list. In fact, I'm going to leave you a link where you can download a cheat sheet on the various objections. I trust this video has been helpful to you. And as always, I'm Advocate Lucinda, your empowerment lawyer. We'll see you next time. Take care.